Testing, testing, one, two, three. God save the United States and this honorable court.
Good morning, everyone, and welcome. Court apologizes for our late start. We have 6 cases on this morning's argument calendar. We'll begin with case number 1, set of consolidated appeals in 22, 1143, 1170, and 1172. The Insurance Company versus Olson, the easiest way to say it. And we'll begin, Mr. Robinson, with you. Good morning.
Good morning, Your Honors. May it please the Court. My name is Ed Robinson, and I represent the estate of Timothy Olson. We're asking this Court to reverse the District Court's determination that the shooter's endorsement in THE's policy bars coverage for Olson's claims. That determination was wrong because under a plain language reading, that endorsement only excludes coverage for one category of fireworks displays, those that are performed by hired shooters. Here, the subject fireworks display was put on entirely by volunteers, and THE concedes that Olson was not hired. Accordingly, his injury claim should not have been excluded. We've set forth the language of this endorsement on page 10 of our opening brief. THE asks this Court to ignore everything that comes before the conjunction or, beginning with, quote, or any other persons assisting or aiding. THE argues that the first clause excludes claims by hired shooters and their assistants, whereas the second clause applies to anyone else, hired or not, who assist or aid in any display of fireworks. But it is black letter law that when reviewing policy language, the Court is required to give effect and meaning to every provision and phrase in the policy language at issue. So here's the point. If coverage is already excluded, as THE argues, as to anyone assisting or aiding in any fireworks display, whether hired or not, then there's absolutely no reason to have the first category at all, which is limited to hired shooters and their assistants. And THE offers no explanation in its briefs for how its proffered construction would not render the first category completely superfluous and meaningless. Beyond that, common conventions of punctuation and structure further demonstrate that hired, the word hired is the operative term to which the entire endorsement is rooted. There is no comma before the conjunction or. As a matter of convention, commas are commonly placed before the conjunction or when intending to begin an independent clause. And conversely, the absence of a comma there supports that what comes after the word or is intended to be a dependent clause, which relates back to the prior clause.
What about the application of the last antecedent rule? Why isn't that the better construction of this? Yeah, by applying that, if you apply that, then hired relates back to shooters or assistants, and the category of any other persons assisting, etc., is its own discrete category.
Yes, I appreciate the question, and I want to focus in answering that question on the phrase the fireworks display in the second clause.
Okay.
And so that is an indefinite article, the. The precedent of the Wisconsin Supreme Court and this court, also in a case involving Illinois law, focus on the fact that the use of the definite article the as opposed to the indefinite article an or any has significance. It has meaning. And so that meaning is when the word the is used, it's commonly understood to refer back to that term if that term appears before. So combined with the fact that there's no comma before that or, that second clause, the fact that they refer to the fireworks display is further support that they're referencing back to those fireworks displays that are hired, put on by hired shooters and their assistants.
Well, why do you need that language to do that work when it says earlier hired to perform fireworks displays? Why doesn't the prior reference to fireworks displays take care of what you just observed?
Yeah, so I'm not sure I understand your question, and it's my confusion, not yours, and I apologize. But that's exactly our point. Our point is This endorsement is trying to get at hired displays. And there's a perfectly understandable reason why the reach of this endorsement doesn't extend so far as to cover pure volunteer displays that we're dealing with in our case.
No, okay, I get that, but you were focusing on the fireworks displays after the or, correct? Mr. Robinson?
Yes, Your Honor.
Okay, and so even focusing on that, I don't know how that helps you with the point that I was asking you to respond to with respect to why isn't there just another category of or other persons assisting in everything we're talking about here relates to fireworks displays. We know that from looking at the language of this.
Yes. So to answer your question, Your Honor, getting back to what I said before, under THE's construction that second clause is an independent second category of claims that are excluded, that would render the first part completely meaningless. The first clause is talking about displays that are put on by hired shooters and their assistants. If the second clause is really as broad as THE is arguing, and it includes bars claims by anyone and everyone that's assisting or aiding in any way whatsoever with a fireworks display, then what is the point of the first clause that's limiting it to hired shooters and their assistants? That's the problem with their interpretation. And beyond all of that, Your Honor, under Wisconsin law, the high hurdle that THE has to get over here is, even if Your Honors believe that their interpretation is a plausible alternative explanation, ambiguities are construed against the drafter here, THE. So the high hurdle they have to get over is not only to convince you that their interpretation is a plausible alternative explanation or interpretation, but it's the only reasonable interpretation, and that they cannot do. Thank you, Your Honor.
You're quite welcome. Okay, Mr. Young, good morning.
Thank you, and may it please the court. I'm Peter Young on behalf of the defendant appellant Todd Zadroik. I'd like to focus on one aspect of Mr. Zadroik's claim that is unique compared to Mr. Olson's. On July 3 of 2018, Todd Zadroik was a volunteer whose duty was to hand light the mortar fuse on a 10-inch mortar at a fireworks display in Land O'Lakes, which is separate from the one at issue in Olson, and indeed his role was separate from the one in Olson. The district court erred in holding that even though Zadroik was not a shooter hired to perform fireworks displays, he is any other person assisting or aiding in the display of fireworks, thereby excluding coverage for his claim under the endorsement. Again, under Wisconsin's rules of policy construction, the policy must be construed as a whole to give meaning to all of the language. In addition, exclusions are to be narrowly construed against the insurer, especially if they're uncertain as to effect. The test is not what the insurer intended the policy to mean, but rather what a reasonable person in the position of an insured, in this case Spielbauer, would understand the policy language to mean. At page 21 of their brief, THE has taken the position that the clear intent of the endorsement was to exclude claims brought by anyone involved in any way with the display of fireworks, such as Zadroik and Olson. But I'd submit it does not matter what THE thinks the clear intent was. What matters is what a reasonable person in the position of the insured would understand. Had THE intended the exclusion to be as broad as it now argues, it could have drafted it that way. In this case, a reasonable person in the position of Spielbauer would understand that shooters are precluded from coverage only if hired. If unhired shooters are lumped in with any other persons assisting or aiding in the display of fireworks, THE's having singled out shooters or their assistant hired to perform fireworks displays in that endorsement would amount to a meaningless surplus phrase. By ignoring Zadroik's role as a volunteer shooter and instead categorizing him as any other person assisting or aiding in the display of fireworks, the district court effectively renders the specific terms, shooters or their assistants hired to perform fireworks displays, to be superfluous, which is contrary to Wisconsin law concerning policy interpretation and construction. This is the conclusion of my brief portion of the oral argument. I see I have time remaining if the court has any additional questions for me.
I think so. You want to cede your time to Mr. Robinson for rebuttal?
Yes, I would, Your Honor. Thank
Okay,
you.
very well. Mr. Burnett, good morning. We'll hear from you. You represent Spielbauer, correct?
Spielbauer Fireworks.
Yeah.
Your Honor, I'm going to address a different question this morning, and that's whether or not the district court inappropriately and prematurely eliminated Spielbauer's contractual rights to indemnity based purely on allegations without any proven facts.
Mr. Burnett, can I ask you a question on that?
Sure.
On that issue? I understand your argument, and it's an interesting argument that you've got two individuals who filed a complaint in state court, and based on that complaint over which you have no say, you say, we don't know whether these facts are right or not. The district judge says the insurance company has no duty to defend based upon what a third party said in its complaint. You have no, it's not your complaint, you're the insured, you didn't make the complaint in state court. But do you have any law that supports the position that under the duty to defend, we should analyze that differently because it was a third-party complaint as opposed to the insured filing the complaint?
No, Your Honor, I don't. I believe under Wisconsin law, the courts are quite clear, and that's the Waterwell case that I emphasize in briefing. The duty of defense is judged purely by the allegations of the complaint. It is.
But whose complaint? That's the problem here. Whose complaint? If it was your complaint, that's one thing, but it's not.
It's the complaint that would give rise to the judgment. So it's not THE's complaint, it is Olson's and Zadroik's complaints that determine the duty of defense. The duty of indemnity, however, is very different. As this court said in Meridian Security, the duty of defense is judged by the plaintiff's allegations. The duty of indemnity is judged by the plaintiff's proof.
So two related questions to it here. We see courts all the time in the state system, including in Wisconsin, resolve insurance cases by resolving duty to defend issues. It's not that once a duty to defend is resolved that, well, okay, the indemnification matter remains open for all purposes, and that's because of that language in those cases that you know where the courts have described the duty to defend as being broader. And related, how is it that you envision that the facts could possibly change here regarding, in particular, the Olson accident that could result in indemnification?
The whole point is that as I sit here today and as THE sits here today, nobody knows how that accident happened. We know how the plaintiff says it happened.
Why wouldn't that be the response? Why wouldn't that be the answer in every single insurance case from an injured plaintiff's perspective, that all you have the authority to do is resolve the duty to defend?
And that, I'm sorry I interrupted you.
No, go ahead. You're fine.
And that is exactly why this court in a dozen cases cited in the brief says you do not decide the duty of indemnification at the beginning of the case.
What's the legal consequence of in all the Wisconsin law where the court has said the duty to defend is broader than the duty to indemnify?
That's based on a fallacy. The fallacy is that the two ideas are related. But as Meridian Security said, the duty of defense is judged by the plaintiff's allegations. The duty of indemnity is judged by the plaintiff's proof.
Is that a sound is it good law in Wisconsin, in other words?
That's where the question of what the Wisconsin Supreme Court has said in the Talley case, where they explicitly overruled the Doyle decision, where the duty of defense and the duty of indemnification coverage collectively was inappropriate. The court in Talley said the Four Corners rule applies only to the duty of defense. And in Waterwell, the court had emphasized in a footnote that the duty of defense the end of the duty of defense, the absence of a duty of defense, may not apply at all to indemnity. So the short answer to your question, and I'm well over my time, the court has spoken inconsistently and most recently seems to be departing from that rule. Thank you.
Thanks to you, Mr. Burnett. We'll turn to counsel for the insurance company, Ms. Economou.
Good morning, Your Honors. May it please the Court. My name is Dina Economou, and I represent THE Insurance Company. It's actually spelled out as opposed to the. At issue here is both a primary and an excess liability policy that THE issued to Spielbauer, which sells and distributes fireworks. The THE primary policy sets forth the coverage that is provided, but equally important, is not provided by the
Could I
policy.
ask you a question regarding this, the policy matter?
Of course.
I understand the argument, and I understand the argument that the appellants have made, which is that it seems like category 1 is sort of specific, and then category 2 is forget everything in category 1, it's everybody. I understand that. But I have a question for you regarding the last phrase of category 2, by the named insured, any shooter or any assistant. Mm-hmm. It seems to me that the way you read the policy language, and particularly category 2, is any other person assisting or aiding in the display, whether or not they are employed, period. It doesn't matter whether they're employed. So by the named insured, any shooter or any assistant is meaningless. Why doesn't that phrase, why shouldn't we interpret that phrase to say whether or not they're employed by the named insured, any shooter, any assistant, consistent with hired to perform fireworks display? In other words, it doesn't matter who employs them. It doesn't matter if they're employed by any of the three. It only matters that they're employed.
So, Your Honor, a few points there. The provision is written such that there are two categories of people created, correct? Hired shooters or their assistants, and anybody else assisting or aiding in a fireworks display. And that latter provision follows the or and is immediately follows the language of assisting or aiding, and simply makes clear that whatever their capacity is, if they're not hired, then they fall into this second category.
Well, even if they are hired, they fall into the second category, right? Because the second category just says everybody. If I was to say you, and everybody else in the courtroom, that would render you, and you meaningless. I could just say everybody in the courtroom.
I understand your question, but here's the point. To interpret whether or not any of the foregoing are employed by the named insured, any shooter or assistant as modifying hired shooters would make hired shooters and their assistants meaningless.
Well, how so, though?
It would be modifying somebody who's already hired.
Okay, think about that.
Mm-hmm.
Yeah, what you're saying with that argument, I think you made it in your brief, is that there's surplus language on both sides of this. I think there is. I think you can argue it on the front side, like they're arguing, or you can argue it on the back side, like Judge Kirsch is pointing out. Because if what follows the or is just a complete catch-all, it picks up everybody, whether they're an employee or whether they're a volunteer. You don't need the first part of it.
Your Honor, that is one interpretation, but we have to deal with the...
No, so the question is, why is it the wrong one? Because if there's ambiguity here, the point that plaintiff's counsel have made is a problem for your client.
There is no ambiguity, number one. The argument that was proffered by opposing counsel was that THE's burden is to prove that that its interpretation is the only interpretation for there not to be an ambiguity, and that's not the standard. The standard is that it's the term, it's only ambiguous if the term is fairly susceptible to more than one reasonable interpretation. We are talking about a one paragraph, 70-word endorsement that simply makes clear that shooters, anyone involved in the display of fireworks in whatever capacity is not covered under this policy. If that type of risk should have been insured under a different type of policy, not this policy.
Can you address Mr. Burnett's argument about why we shouldn't preserve the possibility that the actual facts, especially with respect to the two individual plaintiffs here, they could come out differently on the duty to defend vis-a-vis the duty to indemnify?
Absolutely, Your Honor. First of all, Wisconsin law is different than Illinois law, which is the Meridian case that Mr. Burnett relied on. Under Illinois law, the duty to defend and the duty to indemnify can exist even where there is no duty to defend. Wisconsin law is not the same. Wisconsin law holds that the duty to defend is broader than the duty to indemnify, and where there is no duty to defend, there is no duty to indemnify. The broader duty, if the broader duty does not exist, the narrower duty does not exist. And that's rooted in the concept that a duty to defend only arises where there's a potential for coverage under the complaint. And so therefore, if there is no potential for coverage, then there could be no potential for indemnification obligation. So Wisconsin law is very different than Illinois law.
So is that, if we translate that here, what I was thinking about in preparing for the argument is you'd have to have a possibility where the two named plaintiffs were not volunteers in any way, shape, or form connected to the fireworks events, but rather were spectators or bystanders or something else. And I don't know what there is to suggest that. I mean, that gets so far afield from what are in those underlying complaints. Is that the right or wrong way to think about it?
That's exactly the way to think about it. The exclusion does not preclude coverage. For example, if a bystander a spectator at a fireworks display was injured, it only precludes coverage for people involved in putting on the display. The other to your point, Your Honor, is, look, the nature of the insured's liability here isn't going to change on whether Olson and Zadroik were, assistants or hired. It will not turn on those. It has nothing to do with the application of the exclusion or the clarity of the exclusion. There's nothing that's going to come out in the underlying case that's going to change what they did. They themselves allege, Zadroik alleges, I manually lit the fuses. I was assisting in putting on the fireworks display. For his part, Olson was a container operator. He was responsible for, he operated a metal container that stored extra fireworks, and he would open the lid when volunteers came over to get more fireworks during the course of the display. That doesn't change. That is not going to affect Spielbauer's liability. And that's also why there's no indemnity.
Why is Spielbauer stuck with that complaint? In other words, why is the insured stuck with a third-party complaint when Spielbauer says these allegations made by a third party may or may not be true? They may be false. We just don't have any idea. But the insurance company says, based on a third-party complaint, we have no duty whatsoever to defend Spielbauer against these allegations. You're on your own. All the cases that I could find in Wisconsin are a little bit different. They're where the third party is pleading facts that the insurance company then becomes stuck with, because the court looks at the third party complaint and says, all right, these facts include the duty to defend, and so the insurance company must defend. This is the opposite, where you've got two individual plaintiffs have pled Spielbauer out of its policy, while Spielbauer is kind of the ham and the ham sandwich here, saying, wait a minute, we don't know what's right and what's wrong, and now we have to pay for the defense.
Your Honor, that goes back 60 years in Wisconsin jurisprudence. Under Wisconsin law, dating back to Grebe and cases dated in 1967 case, if not before then, perhaps Maury v. Badger as well. An insurer's duty to defend is determined from two documents. The underlying complaint, Zadroik and Olson's complaints, number one.
But I can't find, that's the thing, I can't find any case law that says that, what you're saying. I got it. I read all the cases that set forth in the complaint, but those cases are the insured's complaint.
They are not the insured's complaint, Your Honor. Choinsky, all of these cases involve an underlying claimant suing a defendant for alleged liabilities in whatever factual scenario. In Wisconsin, the insurer is often brought in as into that case as a direct action, but it is always underlying claimant versus insured, and those are the allegations that are pled against the insured. What did the insured allegedly do that led to its liability? And those cases from those complaints is what the duty to defend is measured against.
And you're saying as a procedural matter, then you have a spin-off declaratory judgment action to declare coverage.
Correct. That's
Right.
the normal procedure under Wisconsin laws. You move to bifurcate the coverage from the liability
So
issues.
is the response to Judge Kirsch's question to get at this concern that there has to be something in the complaint or some other document that bears upon a duty to defend that suggests that the alleged facts are subject to change upon ultimate findings to a degree that could bring coverage into the realistic, into the possible. And that's where I've struggled with this, because I don't see anything in the two complaints, because they would be very far afield from what's in there right now, where either Olson or Zadroik said, I was actually a spectator, or I was a bystander, or I just happened to be driving down the road while the display was going on and I was injured, or something like that.
Correct.
But that's very, very different than what's in those complaints today.
Right. The complaints, exactly, Your Honor. Let me just be clear. The court considers the complaint as alleged, and it looks at based on what are the facts alleged, not the legal labels, not the causes of action, but what are the facts alleged, and if those facts, again, resolving all inferences and all doubts in favor of the insured, if those facts could potentially lead to indemnity coverage, to an obligation for the obligation for indemnity coverage, meaning the insured's held liable and the insurer would have to fund that liability. That's how you determine whether a duty to defend. So where there is no such allegation, as is the case here, there is no duty to defend. And therefore
So you
no
were going to
duty
say earlier the
indemnify.
duty to defend is defined by two things, the complaint, what's the second thing?
The policy. You take the complaint, you compare it against the four corners of the policy, you look at the two documents under settled canons of contract construction, and if there's any possibility for coverage under the policy, there's a duty to defend. Where there is no possibility for coverage under the policy, based on what's pled in that complaint.
So if we hypothetically drastically changed one of these complaints and there was ambiguity as to whether, I'm just going to take one of them, as to whether Olson was a spectator or a volunteer assistant for some portion of the fireworks event, then you'd say, well, we have a different ballgame then.
The duty to defend is always evolving, Your Honor. On these complaints, there is no duty to defend. If there's a material amendment to the Olson complaint, we would look at it anew.
Yeah, so if the amendment was such that it's very possible that Olson was a spectator,
Then I would agree with you that would arguably not be precluded by the shooter's endorsement, because there's a question about whether he was aiding or assisting in the display of fireworks, and therefore the duty to defend would arise in that circumstance. That is not what is pled here.
okay. Anything further you'd like to make, point you'd like to make?
Just very briefly, Your Honor, I think I've actually hit all the points in terms of this distinction between defense and indemnity that was trying to be made. And in sum, I do believe that the district court properly considered the complaints in front of it, properly considered the policy language in conjunction with canons of construction and Wisconsin law on when does a duty to defend arise. If no duty to defend can exist, there can be no duty to indemnify. They are separate but not independent under Wisconsin law. That's an important point. They are separate but not independent. And therefore, correctly concluded that the shooter's exclusion plainly and unambiguously precludes coverage for the complaints at issue here. Thank you, Your Honor.
Thanks to you. Mr. Robinson, we'll come back to you.
Okay.
Yeah, come on up.
Thank you. So briefly, I think I heard counsel just say that our interpretation that that her construction of the policy would render the first clause completely meaningless is one interpretation. We submit it's the only interpretation that harmonizes the entire provision, but regardless, it's at least a reasonable interpretation, and therefore, because it's susceptible to more than one reasonable interpretation, it's construed against THE. It would have been easy enough for THE to have drafted the exclusion broadly to exclude injury claims brought by anyone assisting or aiding in any fireworks display, whether or not hired or employed by anyone to do so. That's not how they drafted their language. Getting back to the issue about whether the remaining part of the provision, which says whether or not any of the foregoing are employed by the named insured, any shooter or any assistant, again, the operative term is hired. As long as it's a hired display, anyone that's assisting in that hired display is barred from coverage, whether they're employed by Spielbauer or the pyrotechnics company. My time is running up. Thank you very much.
Thanks to you. Thanks to all counsel. We'll take the case under advisement. And we'll move to our second argument of the morning in appeal number 213394, Kevin Durant versus Richard Anderson. Good morning, Mr. O'Brien.
Good morning, Your Honors. Thank you. My name is Tim O'Brien, and I represent the plaintiff appellant, Kevin Durant. Your Honors, running for elective office can be a rough and tumble business. In the heat of the political battle, the First Amendment can act as a shield, and it can act as a sword. It can empower a candidate to speak, and it can protect those who speak against the candidate. But the First Amendment is not a shield which allows a campaign of retaliation and harassment, even petty harassment, by an elected official against their employee who chooses to run for office. And in this case, the perpetrators of the harassment, using information that only they got through the employment, were his supervisors and then the newly elected sheriff. No one in this case disputes that Mr. Durant meets his first requirement to prove a violation of his First Amendment rights.
Mr. O'Brien, can I ask you a question just on the
Yes,
facts?
sir.
I just want to understand the facts. I understand that he complains of several acts of retaliation, but the way I read it, there's only 2 acts of retaliation that exist before the sheriff's department found out that he had failed to disclose his sexual assault charge. And what the one is the sheriff refers to him as a bad guy and says he was demoted, and the second one was the increased patrols in the Hague area. Everything else, I think, comes after they found out that he had failed to disclose his sex assault charge in South Carolina.
Well, there's an issue of fact, Your Honor, I believe, on what the sheriff knew and when he knew it.
Well, wait a minute. No, there's all evidence on one side that the people did not review the report, and then you're speculating on the other side that they did, and you want to present that to the jury, but you have no facts to prove that they did. You're just arguing that they should have.
Oh, I understand. Okay, Your Honor, what you're saying is, in essence, what the defendants are arguing is, if we say it, it must be true. But there are laws that they were to follow in what they were to do when they received that clear report. They talk about the NCIC report.
Well, where does the law say they have to run a clear report or they even have to look at it? They can hire whoever they want as long as he's not a felon. And by the way, I think they could hire a felon. If he doesn't have the ability to possess a firearm, I think they can still hire him. I don't know for sure. But in my prior career, I actually came across police officers in some jurisdictions that could not carry a firearm. It's a little weird, but it does happen.
Well, the employment activity, and I lost a little sight of the original question you're asking, but the clear report was provided. It was looked at evidently by two people who were supposed to, and the purpose was to find out, is he a felon? I mean, that's the major purpose of that report, and so they had gotten it. It appeared to be followed the chain of command. One person gets it, looks at it, gives it to a supervisor. That person gets it and says to the sheriff, no issues with this. Now, I understand that they're saying, well, that's not what happened. We just didn't look at what we needed to look at, and therefore, no harm, no foul. But that's not what, that's one interpretation. The other interpretation by the plaintiffs is they were required to look at this, they wouldn't have done it, and that's a question for the jury to ask. Who's telling the truth here? So, I was saying that no one disputes that Mr. Durant meets his first requirement, that his speech was constitutionally protected. But the question is, these deprivations, were they likely to deter free speech, and was it a motivating factor? The district court's ruling, Your Honors, means that if a public employee runs for office, he or she has lesser First Amendment protections if they are retaliated by their own employer. And that is an extremely dangerous precedent, and more importantly, it's not supported by this circuit or any other circuit's law. Now, the defendants have argued, or they're asserting, plaintiff doesn't recognize there's a contextual difference if you're running for office because the give and take of politics. And in making that argument...
Is that a relevant consideration in your view?
It is a relevant well, I better be careful.
No. Is the context that the speech and the alleged retaliation occurred within in the kind of heat of a political campaign, is that a pertinent First Amendment consideration?
I believe it's a pertinent First Amendment consideration, but the difficulty with the analysis that the defense gives you, Your Honor, is they only focus on one part of the equation. What is the employee's First Amendment right if the employee, or what is the person's First Amendment right if they enter the political realm? But there's another side to this, and that is, what is the duty of the employer as to their employee, even if that person is in the political realm?
So this case is very, very easy to get drawn into the facts, because the facts there's a lot of them, it's messy, all that. But what I'm most interested in for oral argument here are some of these legal lines, okay? So let me give you a hypothetical. And what I'm trying to get at is whether an employer can consider something that an employee, to put it in the context of a sheriff's race, an employee said in the midst of the political campaign. So suppose, for example, a deputy sheriff running for sheriff made comments about, if I'm elected, I will not enforce existing prohibitions against the use of X drug. Or further, suppose that the deputy said something that raised real concerns about the enforcement of laws to protect children, can the sheriff employer consider that after the race is over for purposes of whether the deputy is fit to remain in service?
Yes, I think the sheriff could consider.
What's the legal test?
The legal test is whether the sheriff is using it as a part of a pattern of harassment. In other words, is the sheriff retaliating for what the person has said or done, as opposed to if he brings him back in and says, you know.
Well, okay, you got to go further than that.
Sure.
Okay, you got to go further. I think it's definitely responsive to the speech that occurred in the context of the campaign. Don't you have to get more at, wouldn't it deter similar campaign speech protected by the First Amendment by a person of ordinary fitness running for that office?
Yes, it would. And I believe that's the point we were trying to make, Your Honor, is if the person uses their position as sheriff to say, you said this, now I'm going to retaliate. And we allege, of course, he's done it before, and I'm going to change your conditions.
Drop the label retaliation.
Okay.
Okay, forget
Sure.
and because that may be assuming the conclusion. What is it about where we stand with our First Amendment jurisprudence or the Supreme Court that does not permit the employer to consider that speech without stepping over a forbidden legal line?
Because in the employment context, Your Honor, or in the First Amendment with employment, would it deter a person of ordinary firmness from continuing to engage in protected activity? And so if it is the employer using the political speech against the person, then it does impact the First Amendment.
What's the best authority you have for that? That's pretty broad.
Well, the Sarita case, Your Honor, talks about that, and then
I don't mean to throw you off your pins here.
Yeah.
Keep going.
No.
That strikes me as broader than where the Supreme Court is at in this area.
Well, I admit
Because what you've excised from your proposed test is a person of ordinary fitness, and you have to measure the person by the context in which the speech occurs. A person running a political campaign.
and I understand that, if you step into the political realm, then all's fair in love and war kind of thing in politics. I get that part of it. But when you're using information that's only available to the employer through the employment context and using that against the person, if I'm the deputy who's going to run against the sheriff, that makes it a much greater issue. Should I speak out even though I feel I have the right to? Should I do that knowing if my employer can take things from my personnel file and make them public to people? If my...
Okay, go ahead.
What if, Mr. O'Brien, the information didn't come through the file?
If it did not come through the file.
Yeah, I'm just giving you a different hypothetical.
Sure,
And it came to the attention of the sheriff.
Sure, the employer still has a duty not to provide information that well, let me take a step back. So you're saying that a third party just said...
Let's say a phone call from the North Carolina sheriff. He met at a convention. He knows this sheriff and passes on that information.
Well, in this case, it's a little nuanced, obviously, because there are laws in South Carolina, I believe it was, that they shouldn't be allowed to use this information. But if it's simply in the give and take of the political process, Your Honor, I understand what you're saying, and that you should be prepared that people may bring up information that they pick up. But that's not this case, and that's the difficulty sometimes as we try to navigate these cases, that some seem to say that if it's politics, anything goes, some of the district court cases, but when you look at them closely, that's not exactly what they say. They're talking about one political, kind of two people on the city council, for example, saying, I don't agree with you, or you're a Democrat and I'm a Republican, and we fight, but we have the majority. So I think it is a different type of
So the
case.
chief of police here from that neighboring community, is it Aseo?
Osseo.
Asio, okay, asked Semingson what he thought about your client taking a position in Asio. So it's basically a job reference inquiry. Can we at least agree upon that?
Not exactly, because we think Semingson is the one who started the conversation and said, I don't want him here. I don't want him in my county.
Okay, what in the record suggests that Semingson was the one that did the outreach?
There is in the record, as I understand it, Judge, and I didn't write the brief because my partner is no longer here, but the point being, in the record, it says somebody from the sheriff's department contacted Osseo, brought the police chief came to talk to Semingson, and that's when Semingson started making these statements unsolicited. I don't think you should hire him as a police officer. He might have access to certain information,
So your view is that's initiated by Semingson?
the conversation, at least on this issue, was certainly initiated by him, because he's the one who initially said, you know, that he said these things during the campaign.
Okay, well, we can check it as a factual matter. Here's my question. Hypothesize that we flip it. Hypothesize that Osseo reached out to Semingson. Does the First Amendment prohibit him from answering that question if all he has to say is not positive? In other words, I'm about to give a negative job reference, and the question is, does the First Amendment prohibit that? Because to give the negative job reference, to say I wouldn't trust him with personnel records, crosses a line into retaliation.
Well, yeah, in a sense it does, because you have a sheriff who is not being asked for a job evaluation of this person. He's saying he's done things that I won't let him have access to our system if you hire him, therefore you should not hire him. So he is retaliating for Mr. Deeran's initial conversation in the political sphere.
Okay, very well. You want to save a little time for rebuttal?
I do have, yes, Your Honor. Thank
Okay.
you.
Mr. Stadler, good morning. We'll turn to you.
Been doing this long enough where they gave me new parts, so I apologize for the slowness.
No need to apologize. Whenever you're ready.
Good morning, Mr. O'Brien. Good morning, Your Honors. May it please the court, my name is Ron Stadler, and I represent the defendants in this matter, Brett Semingson, Rich Anderson, and Harlan Reinders. The court's questions were very interesting this morning because I think it reflects a fundamental failure by the plaintiff to recognize the actual facts and deal with the actual facts rather than what he would like the facts to have been. When we look at this case, he relies a lot on this claim of there must have been retaliation here, and I'll quote from plaintiff's counsel, because the sheriff relayed information only available through the employment context. It's a nice argument, but it's not the facts of this case. And when you look at the facts, and I'll go back to what you asked about, Judge Flom, third parties, the record here is replete with the fact that third parties learned about the fact that Kevin Durant in 2007 was arrested for felony sexual assault in South Carolina. Now, that information was not in some way privileged, protected, or known only to these defendants. There's ample testimony, and the most testimony that I think is really key comes from Sally Miller. And Ms. Miller kind of has a dual role. She's on the county board. There's no allegations against her that she somehow was acting in that position. But she's a victim coordinator for an abuse organization. She has one of her clients who comes to her, and this is her sworn testimony, and says, I want you to tell the county that Kevin Durant, one of your deputies, was arrested in 2007 for sexual assault in South Carolina. That's the first indication that we have that this is public knowledge. And then Sally Miller goes on, and the plaintiff wants to say, oh, well, she really didn't tell anyone. It was everybody else who told everybody. There is not a single person in the record who came forward to say Rich Anderson, Brett Semingson, or Harlan Reinders told me about this. What you have is Sally Miller's testimony where she says, yeah, I told this guy at a county board meeting about it. I told my husband about it. I mentioned it to Mr. Durant at a public event in front of my husband, my son, other people in the crowd, and the district attorney, and I said to Mr. Durant, tell me about your sexual assault in 2007. So there is nothing in this case about the defendants here having somehow spread things out that they couldn't, shouldn't, or wouldn't have. I'll go back to the clear report because I want to make sure that everybody understands the record on that and what that is. I heard counsel talk about the law requires and duty requires. There is no law and there is no duty to run a clear report. In fact, this is the first time that Trumpeldor County had ever used a clear report. But what a county does, and this is in the record, is it runs a background check. And one of the things that it does, and one of the first things that it does, is it runs the NCIS, National Criminal Database, to see if there's a record on this applicant. And here there was none. The clear report isn't run for the fact that they want to double check NCIS. If it's not an NCIS, it probably didn't happen. And Trumpeldor County has never had a situation where there was information not in NCIS that showed up somewhere else. But what the clear report does is it says, Mr. Durant has lived at these addresses and these locations. He's owned these vehicles. He's had a mortgage on this property. It leads you to know who the person is in terms of where they have lived and who they have associated with. But, and I don't remember who asked the question, but it was very poignant, there's nothing to show that Harlan Reinders saw that clear report prior to 2018. Was it received by the county? Yeah. Lazel said, I kind of got it in a packet and I put it in an envelope and I said, here's my background report, you can check it out. No evidence at all to show that the county saw that and at that time knew. And I just have to say that the only thing that the NCIS or that the clear report actually shows is that Mr. Durant was arrested and charged for felony sexual assault in South Carolina in 2007. It shows nothing about the disposition of the charge. And it would be absolutely remarkable for an employer, much less a law enforcement employer, to know that its applicant for employment was charged with felony sexual assault and just said, oh, that's nice to know.
Mr. Sadler, I have a question. Where do you propose that we draw legal lines here? And the reason I ask that is same reasons I was asking Mr. O'Brien. And one of the points you make in your brief is that Mr. Durant needs to take the consequences, needs to accept the consequences for what he said in the course of the political campaign. And the proposition that, or the authority that you rely upon for that is a labor relations case from 1943.
Correct. I mean,
that the best legal authority that you can come up with that defines the parameters of this dispute between the parties?
It's an interesting dispute and it has layers to it that I think we don't see in a lot of other...
What tests do you propose? it can't possibly be that once the plaintiff speaks in a political campaign, that anything can go for the employer.
And that's not our test.
Okay, what's the test?
And I repeated in our briefs, and I'll repeat it here, it's contextual. And let me draw the distinction
I
on the
think that's
context.
right. What's the test?
And I'm somewhat arguing against myself, but I don't think the test is that once you announce you're running for sheriff, the gloves are off and I can do anything I want to you. And that didn't happen here. But you have to contextualize it this way. I do believe that as an employee who is running for a political office has some greater protections. And I can't take adverse employment actions against you because you're running against me.
Well, wait, they don't have greater protections. They might have the same protections, but why would they have greater protections if they're running for public office? It's just an objective test, right? Under the second prong, the question is whether or not the deprivation would likely to deter the individual from suffering or from exercising their First Amendment, right?
Correct.
And you just take that employee and say, would it deter an objective person in his position or her position from running for elective office?
I absolutely agree with you. My contextualization is that demarcation line between when I am an employee and then May 5th of 2018 when Kevin Durant submits his resignation and says, you know what, I'm not your employee anymore. I am running for sheriff full-time and that's all I'm doing.
All right, so I don't so he's definitely at that point in time not speaking as an employee.
Correct.
And he's speaking on matters of public concern, so we know under Garcetti it's First Amendment protected. What I'm trying to get at is what's the test on the retaliation then? Of course we got to consider the context of the political campaign.
Once he's on that political realm and he's a
And
politician.
you've already agreed it's not everything goes.
No, I'm saying once he's fully political, he's no longer employed. At that point, I would look at it in terms of the cases that we cited in our brief, foot it in the other cases. Politicians need to have a thick skin. And the other thing is, no adverse action was taken against Kevin Durant in his run for sheriff in that political context.
Okay, let me ask the question this way. It's the same exact question. When ASIO reaches out, okay, I'll say whatever they are.
Yeah,
That's
ASIO, perfect.
ASIO, okay. When they reach out, can Semingson say whatever he wants? Or are there any limits on what Semingson can say to the chief of police? When the chief of police says, here, I'm thinking about hiring Mr. Durant, and I'd like your perspective on him. You just ran against him in a political campaign, and you worked with him as a colleague. Are there any limits, in your view, on what Semingson can say?
I don't believe so. And I would point you to Hutchins versus Clark. Court says where public officials' alleged retaliation is in the nature of speech, such speech does not adversely affect a citizen's First Amendment rights, even if defamatory. I mean, you've got to get to the point that there's a threat of coercion or intimidation, that there's going to be punishment or a sanction. And none of that was directed to Kevin Durant. Don't forget, these defendants have their own First Amendment rights. They get to speak. So if Rich Anderson thinks that Kevin Durant's a bad guy...
even a barrel of lies, I absolutely would not hire him. He was embezzling money, he was stealing office supplies, he wrecked 2 police cars, he engaged in several unauthorized shootings. Just make it up. There's no limits on it?
It's a great hypothetical. I think you could expose yourself to a claim for defamation, but I don't believe you expose yourself to a claim of First Amendment retaliation because it was purely in the political context.
And that, in your judgment, would not deter a person of ordinary fitness from running for office if they thought their prior employer could just level a whole barrel of lies on a prospective future employer.
I think that comes with the nature of politics.
Okay.
I do want to go back and just touch on the issue in regard to the question that was asked about, well, what about these things that happened after November 29th? That is the demarcation, because Durant didn't announce until November 29th that he's running for sheriff. And the only things we have after that is that allegedly Anderson says to some person, Durant's a bad guy. Okay, he's a bad guy. That is not something that is sufficient to deter somebody in their free speech. It too is Anderson having his own rights to free speech, that he can say Durant is a bad guy if he thinks Durant is a bad guy. He can go to the assistant district attorney and say to him, he's a lot of trouble. I don't think he's a good guy. That's not impermissible. It's not a violation of Durant's First Amendment rights. None of that is a violation at all. And I want to go back to that point of the things that Durant alleges after he became a politician. Really the only thing he has at that point is Seminson's comments to Osseo. And just to answer the question that you had before, Judge Scudder, it was not that Brett Seminson went to the police chief from Osseo and talked to him about Kevin Durant. The record will show to you that the chief from Osseo came to Mr. Seminson's office to tell him, hey, I'm thinking about hiring Durant.
Unprompted?
Unprompted.
Okay, where's that at in the record?
It's all over in the record, both in his declaration and in Mr. Seminson's testimony.
Who's he? The Osseo?
The Osseo chief,
of
Bill
police?
Prudlick.
What's his name?
Bill Prudlick.
Got it. Okay.
Prudlick supported Durant when he ran for sheriff, right?
Correct. Yep, he had been a Durant supporter, put a sign in his yard. No surprise that maybe he was going to offer him a job after Durant lost.
Which may have been the reason he went to the winner of the sheriff's race, right? Because the sheriff is probably providing some services, I suspect, to the city.
There's a relationship between the two. The city's within the county, so certainly they have a relationship.
He did offer him a job, just not the one he wanted.
Correct. He ended up saying, after talking to Seminson, he said, I'm not going to hire him as a patrol officer, but I will hire him as our training officer. And there was no objection from Seminson about that. He never went to Prudlick and say, I don't want, Durant working anywhere in this county. He never did that. He just didn't want to have him on patrol where he had access to their computerized database, which would give them access to personnel records in the sheriff's department. Just an interesting note in regard to Prudlick. Prudlick was a former deputy for the sheriff's department who himself had been told, you're either going to quit or you're going to be fired because of dishonesty. And his dishonesty was lying over whether he had posted a note, a derogatory note, on a wall. Kevin Durant lied. And he lied over and over and over again. And when he was asked factual questions about the sexual assault, he refused to answer those questions. He doesn't have a right to refuse to answer those questions. He was obligated to answer them. There was no law that said he could invoke any kind of right to refuse to answer them. And he refused. And he was dishonest. Those were ample grounds for the recommendation for his termination. So I see that my time is up, and I thank you all.
No, thanks to you, Mr. Stadler. Mr. O'Brien, yeah, come on back up. Yeah, we asked you a lot of questions. Why don't we give you a couple minutes on rebuttal?
Your Honors, there was a statement made that there were no adverse employment actions taken, or what were the protections, and I'd like to focus just quickly on this personnel file open records issue because no one's asked about that. The defense is stating that a judge decided what could be released. That is not what occurred. The duty is on the county to determine what can be released on an open records request. And you see the retaliation when they release positive information on the favored candidate, but not on the other candidate. So if you look at section 19.31 through 3.3, even if the judge rules on certain issues, it's still up to the sheriff in this case to determine what should and shouldn't be released. So I wanted to point that out because they had talked about there weren't adverse things. Well, that only came through his employment, through his personnel file on what was released. The defense also cites to foot it and we've covered this, I think, in the briefs, but even in that case, Judge Peterson talked about this could be a different case if this person was an employee-employer relationship, but that's not what I had before me. These were, in effect, equals in the political realm. And then in Osseo, again, I want to come back to it because the facts are that Semingson, regardless of who brought who to whom's room, started the conversation by noting, well, I saw you had that Durant sign in your front yard. Clearly bringing it back to the campaign and then saying, I don't think you should hire him.
You really think it's regardless too? Regardless of who initiated it? It's of no legal consequence?
Regardless of who set the meeting?
Yeah.
Or, well, the meeting might not have been anything about hiring him. It might have just been police chief and sheriff meeting, Your Honor.
Okay,
So-
go ahead.
Okay, I see my time is up, and so.
Okay, no, very well.
Okay.
Thanks to both counsel.
You're welcome.
Appreciate it very much.
Thank
We'll
you,
take the
Your
case under advisement. Our third case of the morning is appeal number 221171. Hemp Corp versus Dunn and others.
Oh, thanks. Okay. Thank you.
Whenever you're ready.
Good morning, Your Honors. Counsel. May it please the Court. My name is Nicholas DeStephanis, and I appear on behalf of the plaintiff appellants of Hemp Corp. This case was originally filed in state court, Rock County, in Circuit Court, Wisconsin. After it was filed, there was a motion to dismiss in lieu of an answer, which led to an amended complaint and another motion to dismiss filed by the defendants. There was a hearing on May 10th wherein the motion to dismiss was denied, and then the court retracted its denial, but ordered discovery, invited the plaintiff to file a motion for summary judgment, and invited the plaintiff to explore potentially a default judgment. After the taking of one deposition, plaintiff's counsel inquired as to a potential settlement, received a figure, claimed that damages had become ascertainable, and removed the case to the Western District. In the Western District, we filed a motion to remand, and defense counsel filed their same motion to dismiss, as was in state court. The main issues in this particular case are whether the case ought to have been remanded back to state court due to waiver for participating in state court and for timeliness issues.
Waiver is relinquishment of a known right. They didn't know of the right. I mean, I think that's their position. In order to waive something, you have to know of it. Their position is, we didn't know of it until post-litigation filings, a letter that said the damages were $200,000. Once we knew of it, we filed our motion, we removed the case to federal court, that's it.
Yes, Your Honor, that is what they're claiming. This case has some particular issues. I think you mentioned the fact that they didn't know until after pleadings. In this particular instance, there were discussions prior to suit being filed.
But that doesn't matter under our case law. And I mean, that's a problem for you, right? Because we have clear case law that says it's post-litigation papers and filings. Because if it was pre-litigation discussions, Katie barred the door, right?
Right. And I think, so I agree with what you're saying. I think that point really goes almost more towards the participation in the litigation. So 2 points to that particular question, Your Honor. Under Wisconsin state law, in a tort case, it says a party may not describe what damages you're seeking in that particular case. And that's what happened in this particular instance. However, the statutes in Wisconsin also indicate that for a pleading of punitive damages, It is either twice compensatory or $200,000, whichever is greater. And for that reason, we would argue that it complies with the Walker case, that the defendants were put on notice by the complaint that figures in excess of the jurisdictional threshold were at play. Having said that, I would also point out the fact that...
Hold on, within the four corners of the complaint, you believe that's true?
Within the four corners, by virtue of the fact that punitive damages was claimed in the complaint, and statutorily, by function of statute, punitive damages are twice compensatory or $200,000, whichever
Yeah, I
is
understand the
greater.
argument. Is there any court ever held that?
Yes.
That's enough?
Actually, the Fate Court, the district court coming out of Northern Indiana, and that Fate Court actually, in
Anything
making that
post
decision...
Walker?
I'm sorry, what?
Anything after Walker?
I am not aware of any cases after Walker. However, we would comply that we would argue that we comply with Walker by virtue of that, and so there's the important note to take in that there were these conversations that occurred before the complaint was filed. The defendants waited 7 months into the litigation to ask, what are your damages? And coincidentally, that occurred after they got a pretty negative response from the state court. And, the court in Walker, for its rules, it also does state that the purpose of the 30-day limitation is twofold: to deprive the defendant of the undeserved tactical advantage that he would have if he could wait and see how he was faring in state court before deciding whether to remove the case to another court system. So there are some tensions here regarding fairness and these procedural rules. One thing that I would point out to the court is that it appears as though Section 1446 sub C sub 2 might address this, in that it states that if removal of a civil action is sought on the basis of the jurisdiction conferred by Section 1332, jurisdictional threshold, the sum demanded in good faith in the initial pleading shall be deemed to be the amount in controversy, except that the notice of removal may assert the amount in controversy if the initial pleading seeks, and this is lowercase 2, Roman numeral 2, a money judgment, but the state practice either does not permit demand for a specific sum or permits recovery of damages in excess of the amount demanded, and removal of the action is proper on the basis of an amount in controversies asserted under subparagraph A if the district court finds, by the preponderance of the evidence, that the amount in controversy exceeds the amount specified in Section 1332A. I wonder if this does not permit a defendant, such as in the defendant's instance where punitive damages are pled, to simply assert the jurisdictional threshold right away and have the district court determine whether it's met. That, by doing that, would have allowed the defendant to stay within the 30-day time limitation, avoid litigation in state court, and duplicative proceedings.
Can I ask you a question on the, as you're collecting your thoughts there, just I know one other aspect of this that we may have some interest in is the contract formation.
Right.
That way. You think your client had a contract with some entity or some person when the initial purchase arrangement was undertaken?
I think he believed he was entering a contract with an entity. When he, decided he was going to endeavor this project, grow hemp. You can't go to Stein's, so he went to the internet, and he found this website for CBD Inc., which tends to denote an organizational entity. On the website, it says CBD Inc. is an international holding company with the best high percentage CBD genetics available for the market. So I think he thought he was dealing with a corporation, and that's important.
Well, more than thought, right? I mean, and then they started to perform. Both sides of that started to perform on the contract. Your client placed an order,
Correct.
right? And there was a partial fill.
Yes.
Right. So it wasn't just I'm hoping something shows up. I mean, he not only thought it, but then the deal started to go forward.
Yes, that's correct. Yes, there was a sales order and then the agreement that is in the record, and but the issue is that the defendants' names appear nowhere in that agreement. I don't think
What difference does that make, though? Isn't that an issue for the arbitrator, if there is even an issue on that?
in Wisconsin.
Well, yeah, I read that, but I read that, but I don't think that applies here. I mean, you could, if I wanted to start a business, I could just call the business whatever I wanted to. Let's say I wanted to sell T-shirts, right? Tom's T-shirts,
Sure.
and I could enter into a contract with you where you're going to buy T-shirts.
Yeah.
I just call myself that, and then if there was litigation, you could sue Tom's T-shirts, or you could just sue me, or you'd sue both.
Fair enough. Fraudulent inducement. Not even just the entity itself, but in the product. These seeds were advertised as the best high percentage CBD genetics available for the market. They were advertised as being feminized, which are all things I've had to learn about. They clearly were not.
I get it, though.
Yeah.
How do you distinguish the U.S. Supreme Court's reasoning in prima paint
Your
on
Honor,
fraudulent inducement? Why is that not controlling here?
because in this particular case, on the basis of not knowing who you're dealing with, and the basis of being sold a product that
Right, so you say that led to fraudulent inducement of a contractual arrangement. Isn't that what was at issue in prima paint? And the question is, who decides that?
well, in this particular instance, and I realize the district court decided the arbitrator has to decide that, but if the
Relying on prima
arbitration,
paint, right? I mean,
well,
if I remember right. It's a U.S. Supreme Court decision. Go ahead. I don't want to keep going.
this circuit itself has stated that it is counterintuitive to enforce an arbitration agreement in a contract if the contract itself is in question. So that is really the distinguishment that I would, I'm sorry, Sphere Drake Insurance Limited versus All American Insurance. If it's a question whether a contract came into being, then whether the plaintiff agreed to arbitrate, it is a dispute that cannot logically be resolved by arbitrators. And I think that makes sense because why are we going to force somebody to go to arbitration if, in fact, it wasn't really agreed to? Isn't that the first step that has to be determined beforehand? And really, the issue in that particular case is whether or not a contract is freely and voluntarily made.
Counsel, Hemp wasn't deceived. You knew who Mr. Katz was, right?
I'm sorry, Your Honor.
You weren't deceived, were you, your client?
My client was not deceived.
Right. You know who Mr. Katz was, right? Khan.
No, Your Honor, I didn't. I didn't know that until November. In fact, so these gentlemen with their business practices have left quite a few people very unhappy with them. I asked to take the deposition of a gentleman named Matt Kahn, who was listed on the website,
Right.
the one who signed the agreement.
Right.
And I was called by somebody, a third party who was aware of this litigation, who told me, I had asked him about Matt Kahn. He said, I don't know who that is. Well, he had found out that a gentleman named Matt Lowther had deceased, and informed me that the gentleman Matt Kahn on their website is in fact Matt Lowther, not the same person. He couldn't explain to me why he was using an alias.
You were told Matt Kahn is Matt Lowther.
Correct.
They're one and the same person,
Yes,
and that individual is deceased.
is deceased. In fact, he apparently committed suicide in one of the defendant's homes.
Okay, you want to reserve any time for rebuttal?
I would, Your Honor. Thank you.
Okay, very well. We'll give you a minute on rebuttal, and we'll hear from counsel for the defendants.
Good morning, Your Honors. My name's Attorney Emil Villagale, and I represent the appellees in this matter. Before this court is an issue that shouldn't be here and shouldn't have proceeded this far. And we're asking that the court affirm the district court's decision on all counts. There are primarily three matters here. The issue of the timeliness of the removal, whether or not the appellees in this situation waived their rights, and whether or not there was a valid contract to arbitrate. On each one of these counts, when you look at the statutes involved, especially as it relates to the first one, when you look at the case law involved, when you look at the legal principles involved, it dictates one outcome. It dictates that the removal was timely here, that the defendants couldn't have waived a right they didn't know they had, and that third, the plaintiffs and the appellant in this matter contracted and knew exactly what he was getting into on behalf of his company. There was no fraud in the execution of the agreement. That's not an issue here. As it relates to the timeliness of the removal, this court need not look any further than the plain words of the statute itself, in section 1446, and the Walker case, which is binding precedent in this jurisdiction. It is not in dispute, and the plaintiff can't dispute, that both complaints filed in this matter, including the initial and the amended complaint, did not have a monetary amount stated upon it. Under the statute and under Walker, the only other way, the only portion of that statute implicated are what post-complaint papers were made available and when they were made available. The amended complaint was filed, I believe, sometime in about February in state courts, February 24, 2021. It stated a couple of counts, and then a line that alluded to seeking punitive damages. On April 12th, the defendants filed a responsive pleading in this matter in the state court proceedings, a motion to dismiss. On May 10th, the lower court, the state level in Rock County, had a scheduling hearing. It wasn't a hearing to discuss the motion to dismiss per se. At least that's not what it was scheduled to schedule. But that wasn't what it was scheduled for. During proceedings, there were conversations about trying to expand or at least open up discovery on an expedited basis. Be that as it may, and regardless of what's said in here, it is in dispute. It's not in dispute that the district court never made a decision on that motion to dismiss. There is an actual order to that effect. And so relying on dicta or conversations or streams of consciousness, discussions that I have on the record, and trying to use that to evade the actual order of a court just doesn't jive with what we know and how the law works. As soon as discovery was reopened, myself, on behalf of my clients, reached out to opposing counsel to get some information about what exactly they were claiming. On June 15th, I received an email from opposing counsel on behalf of his client stating that they were seeking sums of over $250,000. The very next day, I had a deposition of his client, and his client confirmed that his damages were in the hundreds of thousands of dollars. Within 7 days of finding out this information, we removed the case. That's proper. That meets the standard. Now, the idea that pre-suit negotiation correspondences can be used as a way to alert litigants of their rights to removal in diversity cases is quite problematic, and has been said, and that has been confirmed by this circuit as well as other circuits that have looked at this issue, because of the host of things that could occur. And under the circumstance, there lies a question. On the record, we don't know, because the letter in dispute or the pre-suit negotiation correspondence was sent to an attorney out in Colorado who had represented a related entity, Latham Prime. There is nothing in the record to definitively prove that that attorney represented all three of the defendants in this case that have been named. These discussions happened over a year before the suit was filed. Most telling of all, and this will kind of get to the oddity and to the heart and why we have Walker and why the statute is written as such. One of the correspondents says, we think we're going to, and I'm paraphrasing, but we're going to be seeking, and we think this case is worth, or, hundreds of thousands of dollars and into the millions, or something to that extent. It's puffery. Puffery cannot be used as a basis for putting a party on notice.
What about Mr. Spanos' point that the punitive damages are clear from the face of the complaint?
Your Honor, that point also presents a deeper issue. On the face of the amended complaint, there is no number attached to it, right? So Wisconsin statute says you have a ceiling, right? Twice as the greater of, so a jury cannot award the greater of twice the amount of compensatory damages, or $200,000. The misconception here and the issue here is Attorney DeStefanis, with all due respect, reads that as a jury must award the greater of $200,000 or twice the amount of compensatory damages. First things first, there was no basis on the face of the complaint to estimate what the compensatory damages were going to be. There was none. There's nothing that says that you cannot state the amount of the contract on the complaint. There is no law that precludes that. Now, yes, we knew that the underlying transaction amounted from a seed deal worth $6,000. It would be impractical to place the burden on litigants and defendants to assume that a $6,000 transaction involving seeds can somehow escalate to $75,000 absent anything else. Or that a jury, if they're able to prove a case at trial, if they're able to meet the standard necessary for punitive damages, for a jury to assume that a jury will give or provide the plaintiff with at least $75,000. And let's assume, and even if I were to make the assumption that yes, the jury gives them $6,000, which is the amount of the contract, it says no more than twice the amount, which will be $12,040 in this context, or $20,000. So that means $12,000 will be the max. And so I think based on the law, based on the facts, based on the statute, the timeliness issue, it's just a non-starter.
Can we get the benefit of your perspective on the contract formation questions and the fraudulent inducement contention and all that?
Yes, absolutely, Your Honor. Again, we look at this, you have to look at this in context of the FAA as well, and also general contract principles. And I do believe that most recently this court had an opportunity to decide or at least rule on a slightly similar case that deals in the formation of contracts. And I believe it was that decision would have been the CCCV retractable case, which I believe was decided June 6th of 2022. And in that case, there's a difference between what we had then and what we have here. It wasn't that there was issues with fraud and inducement, because if it is a fraud and inducement issue, it's arbitrable. That's well within the purview of the arbitrator. This court relied on fraud in the execution. Now, just to alert the court, that case involved a situation where you had two competitors, a trade secret dispute between two competitors. The defendants in that matter had sent out an employee who impersonated himself, used the wrong name, a different name, and lied about where he worked at, and used a fictitious business name and signed a licensing agreement. Now, that employee ended up using the access gained with the competitor to steal the software information, and it was and went back to the prior employer, and they reverse engineered it. This court noted that in a licensing agreement and in that context, the very identity of who you're licensing your software to is important, because at least the facts seem to illustrate that if their competitors knew that, hey, we're going to be given access to a competitor of ours, they likely wouldn't have entered into the contract. Those facts existed in that case. That had to do with a fraud in the execution, not fraud in the inducement. In this case, there is no doubt that the client knows who the parties were. As a matter of fact, the plaintiffs chose not to sue CBD INC, and instead sued the partners, because they understand the fundamentals of contracts, and also in Wisconsin, which says you can operate, the real party behind the fictitious entity are the partners or the entity that uses that name. There is no question here, unlike the tractable case, about the use of this name, CBD INC. And I have to make this point about the use CBD INC. Despite nothing in the record indicating that CBD Inc., and there's a difference here, and it's a marketable difference, it's been brought up time and time and time again. This is not CBD Inc. They didn't represent to be CBD Inc. They represented themselves as being CBD INC. Just because a trade name ends with INC doesn't automatically convert it to something else. There is no...
That's not I don't think this is what you're saying. I just want to be sure. The contention that your adversary is making about fraudulent inducement is not on this point, correct? It's not about the name. It's not about, are these people one and the same? Are people using different last names? It's not that. It's that the quality of the seeds was misrepresented. And is that correct?
That is the contention here. And, Your Honor,
that's the alleged fraudulent inducement.
Yes, Your Honor. And that's what makes this case quite different from any other case, because there is nothing on the record that shows that the arbitration clause itself, and the Supreme Court is quite clear on this, if you're talking about matters, or if you're talking about issues or claims that arise from the contract itself, including fraud and inducement, those are matters that are arbitrable unless you can show that the parties excluded that. That's not the case here. And because the plaintiff's issues and the plaintiff's claims and allegations go directly to fraud and inducement, those are matters that should be arbitrable. Valid arbitration agreement. There are no allegations about fraud in the execution of the agreement. There are no allegations that the identity somehow made the plaintiff, or the identity of the defendants or of the seller had an impact whatsoever on the plaintiff. And we have the fact that there is a broad arbitration clause in here, and most importantly, the plaintiff refuses to submit to arbitration. On these grounds, it is quite clear that the district court did the right thing here on all counts. They found the removal to be timely. They found that you can't waive a right you do not have. And they also found, in addition to that, that a party cannot or cannot be deemed to have substantially litigated a matter in the district court by filing one responsive pleading that hadn't been ruled on. So it doesn't even remotely come close, in my estimation, and based on the review of the facts and the scenario, and found there to be a valid arbitration agreement that the plaintiff refuses to abide by. So we ask humbly that this court affirm the decisions of the lower court on all counts. I will answer any questions if you have any further questions. Otherwise, my presentation's done.
Okay, very well. Thank you.
Thank you very much.
Yeah, Mr. Desponis, we'll give you a minute for rebuttal.
Thank you. Just a couple of points. My contention was never that a jury must award $200,000, only that that's at play, and that is sufficient to remove the case.
Is the fraudulent inducement argument, forget whether it has merit or not, okay? Is it as I described it, or do I misunderstand it?
Exactly as you described it.
Okay.
That's correct. Under the FFAA, it is the defendant's burden to convince the court that there is a valid written agreement to arbitrate. That is why I believe the Seventh Circuit in Sphere Drake Insurance ruled as it is. If there's not a valid contract, there's not a valid agreement to arbitrate. And I'm out of time, so thank you very much.
No, thanks to you. Thanks to both counsel. We appreciate it very much. We'll take the case under advisement.
Thank you.
Our fourth argument of this morning is the United States versus Anthony Lomax, appeal number 21-2274. Good morning, Ms. Christensen.
Good morning. May it please the court, counsel. My name is Joanna Christensen, and I represent the appellant Anthony Lomax in this case. Mr. Lomax's pro se allegations of ineffective assistance of counsel warranted an evidentiary hearing under 2255B. That's the extent of the issue that we're asking for, is the hearing. The court essentially granted...
But he won.
He won, but not a hearing.
Why don't we just skip to the second sentence of 2255B?
The second sentence, Your Honor?
Yeah.
Of
the statute. The second, if we just jump right to the second sentence, it says, if the court finds the judgment was rendered without jurisdiction or the sentence imposed was not authorized by law, etc., the court shall vacate and set the judgment aside and shall discharge the prisoner or resentence him. That's what she did.
Yes, on that issue. He raised other issues.
He just wants a fishing expedition.
I don't think he wants a fishing expedition. This issue that was granted has implications far beyond his resentencing hearing.
How so? Because the way I read it, there's two different arguments I think that are made. There's one in the blue brief and one in the gray brief with respect to the importance of the hearing. The way I read it, at least in the blue brief, Lomax argues that he was entitled to a hearing to prove his counsel was ineffective in 2012 by failing to anticipate de la Tour. But then in the gray brief, he should have had a hearing because with respect to the resentencing, with respect to proving ineffective assistance of counsel with respect to the resentencing hearing.
That was certainly not my intent to make that argument in the gray brief. My argument has been that obviously that portion, the resentencing hearing, the judge is essentially addressed by her order. But prior to the resentencing hearing in 2017, there are decisions that are made between counsel and defendant that were impacted by the lack of challenge to the 851 notice.
But Lomax doesn't make that argument in his 2019 2255 motion.
No, he does not make that argument specifically. He does make the general argument, however, that counsel should have investigated the 851 notice and done a categorical comparison between Indiana and federal law. And construing his pleadings liberally, because he is pro se at this point, that could have implications for his pre-trial decision-making as to whether he pleads guilty, whether he goes to trial. Statutory maximum and minimums can make a difference in a defendant's decision in that point. So that's the issue that the argument on the hearing is essentially directed toward. Obviously the court gave him relief. So it isn't a different argument, but it is one questioning whether he received effective assistance of counsel at trial in 2012, 2013.
You mean before trial? In advising him to plead guilty?
Right. At any point before the first sentencing when he could have challenged that 851 notice. And the government makes a substantial argument about nobody was raising this issue back then. And unfortunately, that's just not the case. If you look at the history of the Elder case, he was indicted in the same district a year later. His case started in 2013. His attorney challenged the 851 notice prior to trial. Now, that issue didn't go anywhere, except then I got the case on appeal, and we have this series of Elder cases that eventually end kind of where we are here. And I guess I take the blame for most of that in the sense that it's related to Mr. Elder. But the important point is that Mr. Elder made the objection, and made that objection in 2014 when Mr. Lomax was still in the district court pre-sentencing, definitely. And so in that case, it wasn't a convoluted, unusual argument that would require defense counsel to have, as the government points out, imagination, scientific knowledge, and legal acumen. People were making it, maybe legal acumen, in that you had to know that other circuits had applied the categorical approach to 851 and 841, which they had. And then if it was a categorical match between the state and federal convictions. And the fact is we now know, with a little bit of hindsight, but we now know that it was not. But those are arguments that were percolating through the circuit at the time Mr. Lomax was proceeding to trial.
Ms. Christensen, let me get the benefit of your reaction to this. It's the same kind of question that Judge Kirsch is asking from a different direction. Okay. And that is that the appeal before us is from the third resentencing, and that alone. Okay, and I know you want to argue ineffective assistance in connection with the filing of the prior 851, and it may have affected the choice on the guilty plea. Why doesn't this implicate an entirely different line of cases? I don't know, do you know our decision in Suggs and the U.S. Supreme Court's decision in Magwood, all around, kind of Slack v. McDaniel from the Supreme Court, all around whether the point that you're raising isn't it best made in a renewed 2255 application? And then the immediate question would be, is it barred as second or successive, or is it not? Why isn't that the proper way to think about this?
Right, and we didn't address that in our briefs. I believe I cited the Haynes case, which is a case in this court, the first Haynes case, where it got to this court and the court said, no, there's not jurisdiction because not all of your issues have been decided yet on your 2255 petition. So, and the time to raise challenges to the rest of those issues is in the direct appeal from the resentencing. That's my understanding of how the procedure works regarding 2255s and resentencing. I can certainly, I'm not familiar enough with the cases that you talked about to address it now. I can certainly do post-argument briefing on that issue because I don't think either one of us has addressed that issue in our briefing.
Yeah, the reason that I'm asking it, of course, is that we're reviewing a 200-month sentence And
300,
I'm sorry,
actually,
it went from 400 to 300.
Yes,
Right,
yes.
okay, it's a lot of time, I know.
Yes.
Okay, we're reviewing that sentence, and we're reviewing it against the backdrop of no record on the issues that you're presenting, because it wasn't adjudicated by the
Correct.
district court, and then that raises the question about what's the proper vehicle for that. Ineffective assistance of counsel, as you know, can get quite fact-intensive.
Absolutely, yes.
That's why we prefer it in 2255, and I mean, I've been in appeals in cases with you where you've said, are you sure your client wants to do this on direct appeal?
Yes.
Okay.
Yes.
But I'm just trying to reveal my thinking to get the benefit, ask Mr. Wood the exact same question. So why isn't the proper vehicle 2255, and hence Magwood and Slack and Suggs and that whole line of cases?
My understanding is the Haynes case addresses that. And
Our court, Haynes?
yes, Stacy Haynes is the defendant's
Okay,
name.
all right, that's good enough.
And I believe it's in my brief because it is in my binder of cases. So
Okay, all right.
I would have cited it. That's my understanding that deals with that jurisdictional issue. And I think it's because of the process of a second or successive habeas is onerous on the defendant, and that may not be the appropriate
Oh, yeah,
place for
they're onerous, yeah, for sure. There's
I mean,
serious limitations.
nearly completely barred, some of us might say. But I think that that's the reasoning for that this is the proper vehicle to make that challenge.
Okay.
Ms. Christian, could you just restate your position on forfeiture?
Sure, on this issue particularly. My position is that Mr. Lomax asked for a hearing on his issues, and that's essentially the issue that we're raising, that he should have gotten a hearing on these issues. Now, the government argues because he didn't make this argument specifically about his pre-trial ineffective assistance of counsel, that bars it. I think it's a separate issue.
Well, even if we construe the 2255 liberally, which we need to, is there even a hint of an allegation on the issue of ineffectiveness at pretrial?
Well, I think the hint would be that counsel didn't make the objection to the 851, and that had been done in other cases in the same district. That would be the hint, but again, without the hearing process, it's hard to know all of the factors surrounding that, which is why a hearing would be necessary under 2255B. So unless the court has further questions, I'm...
No, we'll give you some rebuttal time.
So, thank
Okay.
you.
Yeah, very well. Mr. Wood, good morning.
Good morning, Your Honor. May it please the court, Joanna. Bob Wood on behalf of the government. Haynes, I think we both cited, I know it's in the jurisdictional statement of my brief, just with respect to what gets transported along with the a post-2255 grant of relief resentencing, what issues come up, but I did not even touch this Suggs issue.
No, I know.
at
So
all.
look, if you're not, you understand what I'm asking?
Yes.
Why is a matter related to an original conviction? Okay, why is that properly within the scope of a direct appeal from a resentencing proceeding and not more properly adjudicated within the context of 2255?
Well, I think that it is, as things stand now, that would be a more proper forum for this. The argument didn't occur to me. But I also view it to some degree as he filed his 2255 at the appropriate time. If he had foreseen, if he had wanted to make the claim that is articulated now, he could have moved to amend his 2255. That would have been proper under Mail or the rules, civil rules. And that underscores
absolutely
underscores the forfeiture, which is why I wouldn't want to go completely on the government's position on this. There could be intricacies to the Suggs position that I don't really want to dive into that unless I
think that there's a circuit split on this, and I think it comes out unfortunately adverse to Mr. Lomax.
Sure.
Because I think in our court it's second or successive. If you want to challenge an aspect of your original conviction.
And that makes sense under the congressional scheme. At the same time, at the very least, for the purposes of the arguments that have been made thus far, not supplemental arguments, and we're happy to do that just as defense counsel is, but in my view, the question begs a second question about amendment, which underscores our forfeiture waiver argument. And I know that does not get to the nub of the second successive question, but for litigation and relitigation purposes, it underscores the waiver point. And on that point, on the waiver point, a hearing is not a standalone claim. To even begin asking the question under 2255B as to whether a claim demands a hearing, it has to be that claim. La Fuentes talks about allegations of facts. There were no allegations of facts relevant to his first attorney. Counsel, the question of ineffective assistance of counsel has ad hominem components. His first attorney made all these arguments and succeeded on appeal for him. His remand attorney was the subject of his ineffective assistance of counsel claim, not the first attorney. There's nothing about trial, there's nothing about pleas, there's nothing about that period of time. If there had been a hint, and those are distinct claims. There is a distinct line of Supreme Court cases about how ineffective assistance of counsel works in the plea negotiation process as opposed to other pieces of criminal procedure. That claim just was not raised, but, and so we believe the argument's waived. If it is not, the argument in the government's view can't succeed. And to Mr. Lomax's point about whether the argument was being made at the time, there were categorical approach arguments being made at the time. Of course, Mathis put it in the bloodstream, but Descamps existed, Taylor existed, Shepard existed. People were making these arguments, but I'm not aware of anyone making an argument of this type in 2013. We're talking about January 2014 when this trial happened. In 2013, this court's Harris decision talks about the concept being plausibly apparent in late 2017 given some litigation in the Fifth and Ninth Circuits, but that was a 2017 time period case. Harris was. So the question as to whether this could have been apparent in 2014 seems, in the government's view, conclusive that it was not. No one was making this claim. Even if comparing statutes was common practice, no one was making a claim like this. And to underscore that, as the government cited, the Smith case, this court decided in 2019, which our office handled, and her office handled, no, sorry, it was not her office, it was a different office, handled, there was a categorical approach claim attacking Indiana cocaine predicates, and this argument was not made. So even comparing statute to statute, it was a financing overbreadth claim.
On the career enhancement, can I?
Yeah, sure.
The career offender enhancement, can I turn you to that?
Yeah.
What's the impact, if any, of the recent decision in Justin Taylor?
In Taylor, the Supreme Court's decision in Taylor turned on the idea that if a criminal prohibition includes threats, then because an attempt to threaten does not necessarily encompass force, then the attempt to commit that crime is not a crime of violence.
All right, I know about it, right.
Sure, and I just say that to say murder does not have a threat component. Indiana murder, and because Indiana requires the intent to kill, and which always includes force under Michael Hill, and other, the recent 11th Circuit case we cited in our 28J letter, Taylor doesn't touch Michael Hill with respect to cases like this. And possibly because of the nuances of this court's Michael Hill decision, it's possible Taylor doesn't have to touch Michael Hill at all. Although if Michael Hill were applied to certain robbery cases.
The reason I'm asking you that, Mr. Wood, you know I'm sure, is that if you think about the Adam and Eve back and forth in that opinion, okay? If all you have to do is change Justice Gorsuch's hypothetical, okay, in a way where an attempted murder does not entail the use of somebody's involved in an attempt, but their role in the attempt did not involve anything that would fit within the force clause.
Sure.
That way. And I'm thinking about the language in that opinion that's not favorable to the government on the intent prong of this with respect to attempt. So I hear you on Michael Hill, but the seventh, we're not the last word on this.
Right. And I guess my point is because of the way, and maybe Your Honor's right that Taylor completely scrambles this
Well,
court's
I don't know
jurisprudence
if
on
it does or
intent, on the
doesn't, but I mean,
role
there-
of specific intent. Sorry.
No, go ahead. I think it complicates it.
It may complicate it. It may complicate, this court said in Turner, it may complicate lots of things, reasonable probability, also all kinds of things. But the government's position, we have recently been guided formally on this. The government's position is that Taylor does not change how courts should approach crimes of violence that are intent to use force plus substantial step. And
Okay, I'm not asking you, that's the Solicitor General or somebody's put guidance out on
we
this?
have the appellate section of those come through the criminal division appellate section.
Right.
And the position is, notwithstanding the hypothetical, and my answer on the hypothetical is the most concrete treatment I have seen since Taylor of hypotheticals of that sort is the 11th Circuit's decision, and it's not exactly the hypothetical Your Honor is discussing. Whether Taylor supplies that level of complication.
Okay, let me ask you the more important question rather than the academic one, perhaps, is this issue before us here in your view?
The crime
merits
of violence,
of this?
the merits of the crime of violence.
Yeah, and the reason okay, go ahead.
As I see it, that issue is resolved by Lomax 2, and should be the law of the case in that sense, because there's no intervening there's no intervening change in circuit law that would necessarily alter the law of the case. And then, but the question of
in the argument that I understand Mr. Lomax to be making, Ms. Christensen can help us on this too, I'm sure. Okay, it is a little bit different. It's more rooted in the whole Kaiser Stinson status of the guidelines commentary debate.
Sure, that's fair.
Smith, all that stuff.
Right, and I would say that the Michael Hill argument.
It's a different argument, right?
But it is our sort of our belt and suspenders response to the Kaiser argument. The Kaiser argument is merely to reserve this for the Supreme Court, then there's no need to even get to the Michael Hill Taylor argument. That's just a secondary line of defense for us.
Was the Michael Hill / Taylor, Taylor wasn't even decided at the time of the third resentencing, but is the Michael Hill issue, was that put before the district court as a basis in the third resentencing for not imposing the career offender enhancement?
It was not, and to explain why we did not push hard on waiver on that, it was largely because Taylor was working its way through the pipeline and hadn't been decided by the Supreme Court, and it didn't seem entirely fair, but it is a backup argument to, it's in the shadow of her preserved Kaiser argument.
Okay.
And so not necessarily.
No, very well.
Thank
you. You're welcome.
Thank you, Your Honor. I'll try to address, in Haynes, it's on page 956, where this court discusses when to appeal when you've had a grant of a resentencing in a 2255. And in Haynes, the defendant tried to appeal immediately before the resentencing occurred, and the court said, no,
okay,
you have
and Haynes is, I don't remember seeing Haynes in your brief. It may be there. I didn't see it in your table either.
So I believe it's in the government's
It is in the
jurisdictional statement,
but not
yes.
on this point.
It would, well, I would assume it would provide jurisdiction. That was the assumption that was made, certainly by me, that this is the way this court gets jurisdiction of the case.
All right, we'll look at it.
Again, if we're wrong about that, I think we're happy to brief it, but that's been the assumption. Let me see. I'll talk a little bit about the Kaiser-Taylor impact. The Kaiser issue is before this court because the defendant raised it in 2017 and then apparently abandoned the issue on appeal, raised a different issue on appeal. And if I may, I'll just kind of wrap up this argument. But then for the resentencing after the 2255, asked to resurrect all possible issues that have been raised before, which would include this one, which is why it's in the brief without a waiver argument. So it is primarily a Kaiser-Stinson argument. The Michael Hill, all the Hills may come into play, but I think that Taylor informs it exactly in the way you were discussing with the government.
Okay, very well.
Thank you.
Thanks very much to both counsel.
Thank you.
Our fifth argument of the morning is United States versus Jamel Newburn, appeal number 22-1244. This one's remote, Greg. Okay, very well. We can see both counsel. Can you hear us from the courtroom okay?
This is Ethan Skaggs. I can hear you, Your Honor.
Okay, Ms. Scott, can you hear us okay?
I can, Your Honor, thank you.
Okay, good morning to both of you. Mr. Skaggs, you may proceed.
Thank you, Your Honor. Good morning. May it please the court. I'm Ethan Skaggs, an assistant federal public defender with the Southern District, Illinois. I'm Jamel Newburn's attorney. Mr. Newburn, back in 2005, was charged with possession with intent to deliver crack. He had a relevant conduct of a little over 50 grams, which put him in the 10 to life category for sentencing. He had a prior that subjected him to an 851, which when the government filed the 851, put him in a sentencing range of 20 to life. His guidelines were per offender at 262 to 327. When the Fair Sentencing Act was applied, of course, Mr. Newburn did not get the benefit of that. He did not get the benefit of that till the First Step Act came out. Applying the Fair Sentencing Act to Mr. Newburn puts him from the 10 to life category to the 5 to 40, but with the 851 puts him at a 10 years to life. His guideline sentencing range does not change by application of the Fair Sentencing Act. I filed a reduction in the Fair Sentencing Act for Mr. Newburn. Our main arguments are that Mr. Newburn had post-sentencing conduct that should be considered, and that being several things. His classes he took, approximately 460 hours. He got a GED. He worked while he was in Bureau of Prisons, and 15 years into his sentence, he had no disciplinary history. We also asked the court to consider that there were changes in the law. If you applied the current law, his reckless discharge would put him in a situation where he would no longer be a career offender, and so he would be 10 to life, and his guidelines would go down to 10 years. Of course, Judge Yandel, while we're here, denied the motion to reduce his sentence. It's our contention that the order doesn't show that our arguments have been addressed, and that the record doesn't support that our arguments were addressed. The court has obligations to consider the parties' non-frivolous arguments, and it's necessary to explain and demonstrate the arguments were considered. The order in place, very short order, doesn't mention any post-sentencing conduct. It doesn't address any guidelines changes. With respect to career offender, there is I guess you'd say a reference. The judge notes that Judge Herndon, the previously sentenced judge, who's now retired, had said in multiple occasions that he wouldn't change anything with Mr. Newburn's sentence, whether he was a career offender or not. But that's the closest thing to anything really being addressed in the order. The order doesn't look at post-sentencing conduct. That's not mentioned. The fact that the guidelines would be 10 years is not in the order. Again, it's referenced. The only thing referenced is that Judge Herndon thought that 300 months was appropriate. The difference in circumstances between Judge Herndon and Judge Yandel, of course, is we're talking about 15 years past. Judge Herndon's looking at this case as and doesn't have the benefit of the 15 years of history. 15 years of no disciplinary action, 15 years of taking the courses. Judge Yandel has that, or she has the opportunity to review that. Looking at the post-sentencing evidence, we think that's very probative here. Obviously, if he had a bad history, the government would have brought that up and said, this man has a bad history, you should deny it. So for Mr. Newburn, he has a good history. That combination of the good history while he's incarcerated, the taking advantage of work opportunities, the not getting, and the taking the classes, that's rehabilitation that should be considered. And the record just doesn't support that that's been considered. So we understand, of course, just because we can show a great disciplinary record doesn't mean the court has to grant us any relief. Just as if he had a bad disciplinary record and that could be shown, doesn't mean the court has to deny him relief. Ultimately here, we believe it was the court's obligation to look at the evidence and then demonstrate afterwards that it considered the arguments. And with the order that's entered, we don't think the court has shown that our arguments were considered. So that's all I'd have, and I'd ask to reserve the rest of my time for rebuttal.
Very well, Mr. Skaggs. Thank you. Ms. Scott, we'll turn to you. Yeah, we can't hear you in the courtroom. Check your button.
Sorry about that. I was still on mute. Good morning, Your Honors. I represent the appellate United States of America. Your Honor, we believe that the judge's order was sufficient. We believe in Hawaii, this court gave the district court's guidance on what needed to be done and what may be done. In Hawaii, this court said, look, what a district court must determine the lower penalties and must consider the updated guideline range. And that's what the judge did. The judge said, hey, look, he's now looking at 10 to life instead of 20 to life. His guideline range stays the same, 262 to 327, just like it was before. And then this court said, okay, the court can consider these other factors. And one of the other factors the court can consider is post-sentencing conduct. And that wasn't even in the court's may consider. This was in the court's can consider. So the district court clearly was concerned here by her reference to Judge Herndon's, and we believe by her reference to Judge Herndon's repeated assertions, which we set forth in our brief at the sentencing hearing, at the denial of the first 2255, and at the 2241, that he would have sentenced him the same whether or not he was a career offender, was what convinced her that this motion should be denied. We believe that she did not make this decision in a vacuum, and I think that having her have to write a longer order setting out what the judge already said was unnecessary. This court is very explicit.
Ms. Scott,
about,
can you address Concepcion?
Yes.
Yeah, and let me tell you specifically what I have in mind in Concepcion. The slip opinion that was provided to us by Mr. Skaggs, U.S. Supreme Court slip opinion, if you look at page 16 of it, where the court says district courts bear the standard obligation to explain their decisions and demonstrate that they considered the parties' arguments, and you read that against the backdrop of what the court described permissible arguments being on page 14, including, for example, favorable prison conduct, taking advantage of different programming and educational opportunities in prison. You're right to say that Judge Yandel was not compelled to grant relief But how can you square it with Concepcion?
Your Honor, we believe that Concepcion actually helps us. I mean, we believe that despite that language that Your Honor just pointed out, that the court can't consider these particular things, Concepcion is very clear that the court does not have to provide this long list of reasons as to why it does not want to
I
bring
agree with that. I agree with that. But doesn't Concepcion impose an obligation on the district court, just by its terms, that the district court consider the principal arguments advanced by the parties? And what and what Mr. Skaggs is saying is that where is it within Judge Yandel's order? You're absolutely right that she doesn't have to write a lengthy order or a lengthy opinion. But what can we look at within the four corners of the order that will give us confidence that she met the Concepcion standard? What language in the order?
Well, Concepcion says specifically, Your Honor, that the judge does not have to expressly rebut every argument. And I think that's what the court did. I mean, there's no evidence that she did not consider that this post-sentencing conduct. There's no evidence she did not consider this career offender, this difference in the guideline range. In fact, it looks like she did consider the career offender designation. The Concepcion also says that the district court may in its discretion dismiss arguments that it does not find compelling without a detailed explanation. So, I mean, we think that Concepcion helps us here. We think that there's no evidence the court did not consider these factors, but that the court didn't find more compelling the idea that his criminal history and the prior judge's insistence on saying, hey, I'm going to give you 300 months no matter what, even if you're a career offender or not. And the judge saying, look, I'm going to do the same thing. I believe you deserve 300 months, whether you're a career offender or not.
I hear you. I hear what you're saying. I think what you're doing is you're making the argument that unfortunately didn't prevail in Concepcion. That's the whole point of the dissent that Justice Kavanaugh wrote. That if you start treating these First Step Act motions as plenary resentencing, then everything is fair game, and you're back into all of the procedural reasonableness that would attach at original sentencing and all that. The difficulty that I have with your position is that that's the dissent. That's not the majority of Concepcion. And when you look at the discussion of the cases that the majority included in its opinion on page 14, for example, I mean, it can't be that those are just there by happenstance.
And I agree. I mean, I agree with Your Honor because, that it does say the First Step Act, does not require a district court to be persuaded, but it does require the district court to consider the arguments. And I can understand what the court is saying when the court says, well, how do you as an independent body looking at this order know that she did consider that? And I think
that's the question. That you've got it. That's exactly the question.
So, Your Honor, I think what we argue in our brief and what we believe is that she did not. That the way you can consider it is that she made this decision not in a vacuum. She made this decision with the benefit of all of the sentencing transcript, the prior ruling on the 2255 motion, the prior ruling on the 2241. And she looked at those things and she made that decision. And she could have considered the other things and just not given a specific reason about them. And we think that that's sufficient, Your Honor. We think under Ferlawi that as long as she was very specific about, this is the new guideline, this is the new statutory range, that's sufficient. She does not have to say, and even under Shaw and the others, she does not have to say, look, I considered your post-sentencing conduct, and I think that even with your post-sentencing conduct, I'm still going to give you 300 months. I don't think she had any obligation whatsoever to specifically address each and every argument. That's exactly what all these cases we cited in our briefs say. You don't have to address these arguments.
Well, that's why Concepcion surprised some of us. But it is the controlling law.
Right, and I agree, but it still says, Concepcion still says, not even in the dissent, but even in the regular order, it says it does not require courts to expressly rebut each argument. And so it does not, the judge did not have to rebut each single argument that was made. And that's our point. This post-sentencing conduct, the court was not required to say, I specifically am considering your post-sentencing conduct and I disregard it.
Ms. Scott, do you want us to look to the 3-page order? Is that what you're suggesting, that we read into her order all the...
I think I'm so sorry.
No, go ahead.
I was just going to say that I think her order is sufficient. I think we believe that under the case law, her order is sufficient because it meets the requirements of Hawaii, and she's setting forth her rationale for why she believes that a 300-month sentence is still appropriate and why he should not get a further reduction. She's looking at the prior history.
All right. You've heard our questions.
Okay,
thank you. I think we understand the government's position. Mr. Skaggs, do you have anything further?
Thank you.
Hold on. You got to hit your button, too. We can't hear you here.
No, Your Honor, I do not have anything else. Thank you.
Okay. We appreciate the work of both counsel here. We'll take the case under advisement. And we'll move to our final case of the morning. That's appeal number 22-1149, Jeffrey Lane versus the Structural Iron Workers Fund.
Good morning. Denise Clark representing Jeffrey Lane.
Good morning to you.
May it please the court. This court has shown Chevron deference to the Department of Labor's regulations under ERISA for rights of action under the statute. George versus Junior Achievement of Indiana was a 2012 decision of this court, which discusses that deference, in particular as it relates to claims and appeals and the administrative process. And as a consequence, many courts have concluded that those claims and appeals processes need to be followed before litigation is commenced in federal court. The Department of Labor has been issuing regulations under ERISA as it relates to the claims and appeals since 1977. They were amended in 2000, again in 2001, and most recently in 2016. Those most recent regulations went into effect in 2018. Those regulations were specifically drawn up to address disability benefit claims and appeals. In that process, the department identified specific issues as it relates to the adjudication of disability benefit claims, in particular as it relates to the disclosure of information that is found by plan administrators as they are adjudicating these claims. The department's emphasis, and it always has been, is to provide disclosure to participants so that they know how to respond to a plan administrator, fiduciaries, trustees. Jeffrey Lane was entitled to a copy of the independent medical examination in this case. He never received it. As a result of that, he was not able to respond in total to his benefit claim denial. Further, I think there is an issue regarding whether or not the plan properly interpreted its own plan language. Under Section 4.01 of the plan provides for two particular circumstances when you are eligible for benefits. One, if you have 15 credits with at least one in a contributing period of the calendar year in which you become totally and permanently disabled. And the other is if you have 5 pension credits when you become totally and permanently disabled from an accident sustained on the job for which you become, while you were on the job as an iron worker, for which you become totally and permanently disabled. The problem with the plan is its definition of totally and permanently disabled. Under Section 4.03A, which in the record is 13-9 at page 27, only has one definition: entitled to benefit payments from SSA, makes you totally and permanently disabled. It doesn't comport with 4.012, which is where Mr. Lane became eligible. In other words, it definitely aligns with the first provision. You're totally and permanently disabled, you've got your 15 credits, you don't have to be totally and permanently disabled on the job. You just have to be receiving Social Security benefits. But if you were to align the provision that Mr. Lane was under with the definition of totally and permanently disabled, there would be no inquiry about whether or not he was injured on the job, because he was receiving benefits. He received an award. He was eligible in July of 2018 to receive those benefits, the same month in which he was seeking to retire under the terms of the plan. So if our first primary argument here is that the plan administrator and trustees basically used a new version for becoming permanently disabled without providing a definition of how to show that you are totally and permanently disabled. Social Security does not issue awards in which they say it's this date, it's this injury. They look at the totality of the person to determine when they become totally and permanently disabled. In reaching their decision, they certainly took into account what he suffered in 2014, but also, as he said to the plan administrator in one of his pieces of correspondence, he attempted to return to work in 2017 and suffered another injury. And there is evidence in the record that shows that he had an injury, and there's evidence in the record that shows that the plan administrator was on notice. So for Social Security to have only considered the May 2014 injury alone would have been impossible, but they certainly would have considered his totality of work. And the fiduciary should have taken into account that this gentleman was injured on the job at least in 2 years and should have explored it further. Full fair review is what we're talking about here. The Department of Labor has been very specific about this in their regulations from 1977 to date. But more importantly, as I've pointed out in our briefs, and I'll emphasize again here today, this plan adopted the 2016 rules, specifically the full and fair review provision and 7.06D of the plan. Unfortunately, they did not apply the terms of the plan. So in 2 instances, there was a failure to follow the terms of the plan.
Is this your point about the failure to provide a copy of the independent review report that Dr. Sterling did?
That's correct. Okay.
Have you received a copy of it today?
No, I have a copy of the
MRI. Do you have a copy?
That was
when did it become
received
available?
When he received the denial. So not before the final determination was made, which
pre-appeal or post-appeal?
It would have been post-appeal.
Okay. When the appeal challenging the denial was affirmed or upheld?
Correct.
Okay. Even though you didn't have a copy of it, did you know the basis for Dr. Sterling? Was there any communication about the substance or the findings that Dr. Sterling had made?
Not to Mr. Lane, no.
Okay. He knew that some independent review was going on?
No, he was not told there'd be an independent review.
Okay.
I'm actually past my time, so I'll reserve.
Well, you can, okay. We'll give you some rebuttal time. No problem. You're fine.
Okay.
Don't worry about it. No problem.
Did you, okay.
Yeah.
All right.
Okay, Mr. Kroll, good morning.
Good morning. May it please the court, my name is Jeffrey Kroll and I represent the appellee, the Structural Iron Workers Local Number 1 Pension Trust Fund. This court should affirm the district court's well-reasoned decision for 3 reasons. First, this court should affirm the district court's decision, which affirmed the trustee's decision to deny Mr. Lane's application for disability benefits because the decision was reasonable. Second, this court should affirm the district court's decision because any alleged regulatory shortcomings asserted by Mr. Lane for the first time on appeal were not developed at the district court level and therefore are waived. Third.
And what specifically do you have in mind there?
With respect to what was waived?
What wasn't properly developed?
Any argument with respect to the particular regulation under, what is it? 29 CFR 2560.503-H4.
Okay, all right.
Not there.
What about the point I was just talking to Ms. Clark about with respect to the Dr. Sterling's report, the report of the independent reviewer?
First off, opposing counsel is incorrect. He was informed that review was going to occur in a letter from June of 2020. Regardless,
a form that it was going to occur, and then what did he learn about its outcome, about the findings that were in the MRI report?
In Dr. Sterling's IME report, he learned that following the appeal denial.
He learned that he was denied. Were reasons given?
Of course, there were reasons given. The trustees relied on the IME, the independent medical examination from Dr. Sterling, as they're entitled to do.
And where is there a letter or something in the record that you have in mind that would have told Mr. Lane that?
Absolutely, Your Honor. There's I believe it's in the administrative record under Exhibit F. Okay. It's our letter to Mr. Lane. It's dated August 20th of 2020. And in this letter, it states, further, the independent medical review found that your medical records do not support a finding that your disability determined by the SSA is the result of an on-the-job injury. He was made aware of the trustee's rationale for the decision. Now, going back on this waiver issue, I think it's important that this court note that the record is silent, ultimately, on whether or not that IME was ever given to Mr. Lane prior to the appeal decision. I don't know whether or not it was given to him or not. And you know why? Because Mr. Lane never developed any of those facts at the district court. He could have alleged in his complaint, first off, that was not given to him as allegedly required by these statutes. There was no such allegation. There's no reference to a failure to do it in any of the summary judgment briefings either.
And this is the Sterling? When you say IME, you're talking about independent medical examiner, and is that Sterling?
That's correct.
Okay.
So there's nothing in the record because it wasn't developed at the district court level. Of return of this case, Mr. Lane wants the pension fund to do his work. And the record actually shows that it gave him several opportunities over a 6-month period to provide documentation which showed that there was a causal link between his May 24th injury and his disability. He eventually produced a letter which the trustees determined actually supported a denial because his own treating physician, Dr. Cordes, indicated there was a multitude of different injuries which ultimately led to his disability. And it was only after that denial that Dr. Cordes made his own clarification letter in which he identified and clarified in a one-sentence opinion that the disability was caused by his May 2014 on-the-job injury. Now, looking back at that, with respect to the May 24th, 2014 injury, the trustees then said, okay, we're going to set it off as they're required to have Dr. Sterling or any other independent medical examiner. Dr. Sterling was who happened to be selected from the panel. to review that decision. And ultimately, that opinion, from Dr. Sterling was the opposite of what Dr. Cordes indicated in his clarification letter. And the trustees, because the plan here has Firestone discretion in it, are entitled to deference in whether or not, and what opinion, medical evidence before them they look to and ultimately conclude and make their decision on. And that's what happened here. And under this court's precedent, under arbitrary and capricious, it has to be downright unreasonable. And to say that when there's a process where Mr. Lane is given every single opportunity to provide documentation which supports that he is disabled as a result of that on-the-job injury, and it's not just an on-the-job injury, importantly, it's actually an on-the-job injury that's sustained while on the job and employed by a contributing employer as an iron worker. So if there's any sort of illusion that Mr. Lane's counsel is alluding to here about another injury in 2017, there is nothing in the record that indicates that 27 injury that she appears to be referring to here meets that requirement that it be an on-the-job injury working as an iron worker for a contributing employer. What's more, Mr. Lane only had 9 credits, and he began in this apprenticeship program in the ironworking industry in the 1980s. So one can presume that he was working in a lot of other areas outside of ironworker if he only had 9 credits over a 30-year period. Now, with respect to our waiver claim, our waiver argument, I think it's clear that this court shouldn't even get into that, first because there's no fact in the record whether or not ultimately the IME was provided to him, as Mr. Lane alleges it should have been. Second, she didn't raise it.
Hold on, are you suggesting it was?
No, I don't know. There's nothing in the record indicating...
Well, the letter you were talking about earlier didn't say, and attached is a full copy of Dr. Sterling's report.
It was provided to him after the appeal. Her argument is that this should have been ultimately provided before the trustees decided it on appeal.
Well, I thought the whole point was the report was prepared while the matter was on appeal.
Of course, absolutely.
Well, it wouldn't even have existed.
That's correct.
Once it came into existence, they wrote him this letter that you were referring to, Exhibit F.
Correct.
Did they attach the report to Exhibit F?
I do believe that, let's see here. Yes. It's a paragraph, the last paragraph of the August 20th letter, it says the last sentence is a copy of the MRIOA report. So it was included.
With that letter?
Correct. The August 20th, 2020 letter. So with respect to Mr. Lane's arguments on Chevron, those really weren't raised anywhere in the complaint. I'm not sure exactly where she's going with that. But on the other component here regarding the application of the plan terms, first off, this court in Seratano held that the trustees, when there is Firestone discretion, their interpretation of the plan terms should be entitled to deference. So we should all be looking at this under that guise. Now, her argument, Mr. Lane's argument, that Section 4.03 gives him ultimately a benefit would essentially negate the distinction in 4.01A1 and 4.01A2, which Mr. Lane's counsel referred to here moments ago. 4.01A refers to participants that have 15 or more credits. 14.01A2, the first component was 4.01A1 refers to 15 credits. 4.01A2 refers to individuals with less than 15 credits. So if you were to agree with Mr. Lane's argument, you would essentially negate any sort of distinction made between those two, because 14.01A2 for participants with less than 15 pension credits requires that it be as a result of an accident sustained while on the job employed by a contributing employer as an ironworker. And the record here shows that the trustees gave Mr. Lane the opportunity to produce evidence which demonstrated that he satisfied that requirement. He ultimately provided a clarifying letter from his treating physician. The trustees obtained an IME from an independent doctor who concluded differently. And the fact that Mr. Lane doesn't like it doesn't mean that it's wrong. All that's required under this court's precedent is that it be, in order to overturn it, that it be downright unreasonable.
Okay,
and for
thank
that,
you, Mr. Cole.
I'm sorry I'm over.
You don't have to apologize. We got your position. Thank you
Thank
very
you.
much.
Very quickly, Your Honor, as to the August letter that was referred to by the appellee, that's the denial letter. That's what the report was attached to. So
it sounds though like the review was undertaken because, at least as I remember the record, Mr. Lane raised a meaningful enough question about what was the cause, of the disability that they got this Dr. Sterling involved.
That's correct.
Okay.
But
the report couldn't possibly have been disclosed until the work was done.
But the plan document itself says he is supposed to get it within and be given time to respond to it. And that was the point I was making with regard to the Chevron difference to the Department of Labor's regulations. 7.06D of the plan adopts that provision, and it says that the participant is supposed to be provided that plan provision and states that that individual is supposed to be given time to respond to the new rationale that has been produced by the participant, by the plan administrator. And that the reason that it's important here is that multi-employer plans are given a different time frame within which to make plan decisions. They can do it on at their quarterly meetings. So if they had provided Mr. Lane that report, given him time to respond, they certainly could have timed it to their next quarterly meeting. That would have then been the time when they closed the appeal, and issued the denial. The other thing that I want to speak to, if I still have some time, is that the plan, I want to emphasize that the Supreme Court in Cigna versus Amara made it very clear that you're supposed to be looking at the plan terms as written. The idea that this was a reasonable decision where you are disregarding plan language, adding language into a provision that doesn't exist, in particular a requirement that there had to be a Social Security determination that said you were injured on the job at that particular point, and to disregard a plan amendment that you put into the plan to specifically comply with the 2016 regulations, I think demonstrates that there was arbitrary and capricious decision making here. And finally, I think with regard to whether or not Mr. Lane was working as an iron worker, there were no facts ever presented. They never challenged whether or not he was working for a contributing employer in 2014 or in 2017 when he was injured. So he certainly met those requirements. For this reason, I think it's important to remand this matter back to the district court for full consideration of all facts. Thank you.
Ms. Clark, thanks to you. Mr. Cole, thanks to you. We'll take the case under advisement, and the court will stand in recess. Thank you.